Hi, I'm Don McHugh.
I'm Vince Macri. We're of the law firm of McHugh and Macri. We are two of 425 certified elder law attorneys nationwide.
We're going to talk to you initially about power of attorneys. But unlike David Letterman with the 10 questions, we're going to give you answer number 1 right away. Question number 1. If I grant a power of attorney, am I giving away all of my control? Answer. You are not giving up control over your affairs. A power of attorney authorizes a person to act on your behalf. It does not direct them to do so. You must remember that a power of attorney has a fiduciary responsibility to act on your behalf. Typically, if we have a husband and wife situation, we make them the power of attorneys for each other. So that way, all of the control stays within the spousal unit. Even when we have to go beyond the spouses, typically to the children, the responsibility for them to act on the parent's behalf remains. That is a very important factor, and if ultimately you can't come to terms with the power of attorney person, you always have the option of simply revoking the power of attorney.
Question number 2. If I appoint only one of my children as power of attorney, the others will be hurt or there will be a conflict. The solution to this question is to appoint multiple agents on the power of attorney document. They can be appointed jointly or severally, which means they can act independently or in concert with each other. When there's a joint or several appointment, it doesn't mean that you need multiple signatures on a check, for instance. Any one of the agents, one of the children for example, could sign the check alone. We can also have some checks and balances where there are transactions in excess of $10,000. Those particular transactions would require more than one signature. Logistics are often a concern in choosing an agent under a power of attorney. For example, if a client has a child in New Jersey and another child in Texas, obviously the child in New Jersey would be the more likely candidate to handle the affairs of the parent in New Jersey. Nevertheless, as I said earlier, we can have multiple powers of attorney. And as I said earlier, it doesn't require one person to get the consent of the other person to do transactions. But we often tailor the documents to provide that transactions in excess of $10,000 require more than one signature as a form of checks and balances. Lastly, when we do these documents, it is the children who make the decisions, not the daughter-in-law or son-in-law. In our opinion, the in-laws are outlaws as far as your elder law plan is concerned. So we're very sensitive to having the child be the one that functions on your behalf.
Question number 3. I already have a power of attorney, so I don't need a new one now. Answer. That may be true. However, few people are aware that in 2004, a very significant change in the New Jersey power of attorney law states that if you're going to authorize the power of attorney to gift, transfer your funds, or engage in asset preservation planning, that authority must be stated in the document. The old way, that the omnibus clause in the document that said the power of attorney is authorized to do anything that I could have done, is no longer sufficient. Further, the power of attorney must be a durable power of attorney, which means it continues to remain effective even in the event of your disability.
Question number 4. My power of attorney could admit me to a long-term care facility even if that is not my wish. Nothing could be further from the truth. This is a common misconception. By signing a power of attorney, an individual does not relinquish any of their rights to do it themselves. You can do it, or your agent can do it. I like to analogize it to an extra set of keys to the car. You can continue to drive the financial car, or your agent can drive the financial car. So by signing this document, you don't give up your right to countervail anything that your agent does that you don't like. As a matter of fact, you can even go so far as to revoke the power of attorney. Incidentally, when we prepare these documents, we often have a clause that you would prefer to be treated at home, if at all possible, rather than be institutionalized in a long-term care facility. We call this our anti-nursing home clause. But be assured that when we do a power of attorney for a client, we tailor it to the client's desires and needs.
Question number 5. I can obtain a form power of attorney online or in a legal stationery store to avoid the cost of preparing one. Answer: this is as true as the adage that you get what you pay for. The power of attorney document is the most important document that you need during your lifetime. The will determines who gets what you have when you're gone. If you don't designate a power of attorney to assist you with matters while you're alive, there may not be anything to leave by will. Boilerplate documents where you fill in the name are not sufficient. As an example, the power of attorney that we use as certified elder law attorneys in Clause 15 has a number of options which the client selects with our advice to tailor the document to their own set of needs. A power of attorney is not like a pair of socks where one size fits all. It needs to be tailored to your individual needs. Finally, we must make the power of attorney durable, which means it is continuing in existence during and if you become disabled during your lifetime.
Question number 6. Will the power of attorney be honored by my bank and financial institutions, or must I use their form? This is a common question. The simple answer is yes. Financial institutions and banks are statutorily required to honor a power of attorney. However, on almost a weekly basis, we receive examples where a client complains that the bank has told them that our power of attorney is insufficient and that the client, or the principal in most cases, needs to sign a bank form of power of attorney. This is absolutely incorrect. Banks are statutorily required to honor a general durable power of attorney that is validly executed. So I often am placed in the position of writing our standard threatening letter to the bank, pointing out that they are financially responsible for any mistakes that are made or any damages they cause by failing to honor a validly drafted power of attorney. However, the bank or other financial institution does have the right to verify that the principal, the person who gave the power of attorney to the agent, is still living and that the power of attorney has not been revoked.
Question number 7. If I am gravely ill and I wish to avoid the time and expense of probate, can I authorize my power of attorney to withdraw all of the funds in my accounts? Answer: the answer is yes, that can be done, but we also need to understand the following. The power of attorney authorization ends upon the death of the person granting it. Therefore, nothing can be done by the power of attorney after death because the power of attorney dies with the person. The second thing of importance is many times that fact is not critical because the same person may also have been designated as the executor or the administrator or representative of the estate. In that case, the person is merely taking off their hat as power of attorney and putting on a new hat as executor, and then they are authorized to handle all of the estate matters.
Question number 8. When I went to the bank, they suggested that rather than a power of attorney, I name one of my children as the joint owner of the account. Unfortunately, this advice can have devastating results. By naming your child as a joint account holder, you are inviting your child's problems into your account. If your child is divorced, if your child declares bankruptcy, if your child is sued and obtains a judgment against them, those unfortunate incidents involve your account. Your account could be levied upon. Your account is considered equally the child's money. You don't want this to happen. It's much better to have the child be an agent under the power of attorney, which means the account is yours, the child just has rights to do transactions on the accounts. So I don't pretend to give banking advice, and bankers should not pretend to give legal advice. You need to deal with experts in these fields who will guide you in the right direction and who know the pitfalls of what can happen if the advice is misplaced.
In conclusion, this is a very important area of the law for elders and the disabled. The power of attorney document is the keystone document in the planning process for seniors. Both estate planning, tax planning, and asset preservation planning all rely on the power of attorney. Therefore, do yourself a favor and do a competent power of attorney document appointing someone you trust.
Hopefully we've dispelled some of the myths regarding powers of attorney. A common misconception is that because a couple is married, one spouse can do anything the other spouse can do financially. This is simply not true and can sometimes require the expense of going through a guardianship for a disabled spouse. You don't want this to happen to your family. So take our lead on powers of attorney and pay attention to this particular document.
That's it. See you on our next video.